Okay. Go.
You hand me my screen box.
Now go. Freak.
This is case number 234478001. The people of the state of Michigan versus Alexandro Pacheco. Defendant is charged with, I think it's brandishing. I didn't bring it down here. What's the official term? Assault or assault and battery. And today is the day set for hearing with respect to the defense motion to suppress. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, P number 83505. And Judge, I understand that everybody's in the courtroom. So if the court can't hear me, I will just try to put my headphones in just to keep my voice up so that the court and the court reporter can hear me.
No, we can hear you.
Yes.
Real well.
Okay.
Mr. Flanagan wants to turn it up. I don't know. All right.
Eric Clark, P31126, appearing on behalf of Mr. Pacheco, who stands to my left.
And your number?
31126.
And then your name?
Alejandro Pacheco Rosario.
Thank you. And then just so you know, counsel, the court reporter is here. She's on Zoom.
Okay.
You just can't see her because she's off camera, but she's on Zoom. All right, so today they set for hearing with respect to Mr. Pacheco, you can have a seat.
Okay.
With respect to the defense motion to suppress. I have read the motion. I have read the people's response. I'm gonna let you make argument, but I am gonna tell you, counsel, so I know I said that I will let you all know if I was gonna set a evidentiary hearing. So I was thinking, I was waiting to see if you were gonna file a reply. And here's why. So when you make your argument, I'm gonna tell you that the reason I have not set an evidentiary hearing is because of the people's response on page 2 and their reference to people be tyranny. And
Did you say people be tyranny?
Tyranny, TIERNEY, 266 Mishap 687. And then at page 703, that's her site, and then 2005 case. And that talks about the lack of reasonable expectation of privacy on a porch. And so I wanted to hear your response to that, because so just in making your argument, and if you have a response to that,
I'll make that argument up front.
okay.
Before I do the rest.
Okay.
I have cited the state of Florida versus Jardius, which is a 2013 case, which was decided by the U.S. Supreme Court, which held that the front porch of a home is in fact part of the home itself for Fourth Amendment purposes. As a result, there is a higher expectation of privacy when you go to search a home, and the porch is part of the home. So this is a Supreme Court case and a 2013 case, not a 2005. So
And I'm going to do some protesting because you know what? I haven't highlighted, but for some reason, I said YT signed up for the case. I literally did, but it's a U.S. Supreme Court case.
correct. So it takes precedent over the state case.
Okay.
But in any event, Judge, I have no objection to the court setting an evidentiary hearing. And the reason I say that is Ms. Ritter, during discovery, has provided me with a body camera video that shows the entire event from the moment the police pull up to their various searches, to the arrest of my client, from start to finish. What it shows is that based on a radio run, they come to his home, which is a fourplex. He lives on the bottom apartment, and each apartment has their own porch. When they arrive, my client is simply sitting on the porch, doing nothing, sitting on the porch. They approach him immediately, apparently based on identification from the complainant and simply ask him to stand up. They arrest him, they put him in handcuffs, they search him with negative results, and then place him in the patrol car, which is on the other side of the street down a few houses, and secure him and detain him there. They then come back and talk to the alleged victim, who tells the police that my client was seen by his truck, with a gun. The truck is parked on the side of the house, not near the porch, and not walk around.
And you're telling me this based on body cam?
Yes.
Okay, yes, go ahead.
And they search the truck, don't find anything. The body cam then shows the police searching the front of the house, the grass, the landscape, the trees. Again, nothing. A short time later, one of the officers then goes up on the porch. My client is a scrapper back then. I'm sure the court is familiar with it. So he has bags and stuff where he keeps on the porch. The video shows the officer kneeling down behind a number of bags and eventually pulling out a BB gun. It is our position that because there is no search warrant, that one was required to search his home, especially after he's secured and no danger to anybody. He's detained in a police car. There's no urgency, there's no extrinsic circumstances that exist to not get a search warrant for his home. Plain and simple.
Ms. Ritter, what's your response? Because I agree with defense that Florida v. Jarvis would supersede People v. Tierney. People v. Tierney is 2005. Florida v. Jarvis is 2013, and it's a U.S. Supreme Court case. And it says that the search of the defendant's porch was unlawful since there was no exigent circumstances. Well, I'm sorry, without permission or another license. That's what the police officers were conducting an unlawful search when they searched the person's porch. So what's your response to that?
Well, Judge, the people's response is that in the case that people cited on People's Response page 2, as the court pointed out, People versus Tyranny, that defendants did not have a reasonable expectation of privacy in the enclosed porch of his parents' home. That's cited from the case law that was provided by the people. And the police officers could.
That case predates the Supreme Court saying a person does have a right to privacy on their porch.
Understood, Judge. So the case that was cited on page 2 talks about the officers going into a common area where visitors are expected to go, i.e. the walkways, the driveways, and the porches. I think that the people pointed that out because, like Mr. Clark stated, the defendant lives in a multifamily duplex, I would say, and the complainant witness lives on the top unit. So it's a duplex where there are units on the bottom and then units on the top. So the people added that in their response because that porch would be considered a common place where places of visitors will go. And in response to Mr. Clark's motion, the U.S. Florida case that was cited states that the search of the defendant's porch was unlawful, especially since no exigent circumstances existed. So going back to the facts of the case and just adding a little more detail according to the investigator's report, there was a 911 call placed by the complainant witness to dispatch that the defendant was seen with a handgun. So at that time, it wasn't known that it was a BB gun, but it mimicked a real handgun. So there was a 911 call placed by the complainant witness. Officers were dispatched to the location where they spoke with the complainant witness, and the complainant witness showed them the alleged picture of the defendant holding this handgun outside in the driveway. So the officers searched the defendant, Mr. Pacheco. They didn't find anything. They placed him in the back of the police car, and then the complaining witness told the officers where they last seen Mr. Pacheco with this handgun. So with that information, the officers searched that area, and that's where they found this handgun, now known to be a BB gun, in these trash bags on the porch. So if the court doesn't agree with People versus Tyranny, I asked the court to look at People versus Bouchelin, which was referenced in People's response on page 3. And in People versus Bouchelin, the court found that under the exigent circumstances exception, that the element of probable cause and reasonableness was determined that there was an emergency circumstance in that case. So comparing People versus Bouchelin to the instant case, Your Honor, I believe due to the 911 call from the complaining witness that there was a gun, that the defendant did have a gun, and that the officers came out, searched the defendant, and didn't find anything and detained the defendant, that the officers then searched the porch due to the 911 call, and that's when they discovered the handgun. So the court then held in that case, well, in People versus Bouchelin, Your Honor, the court mentioned the case, and I'm reading from the opinion, the full case. I didn't put the full case, Judge. I did put the citations for People versus Bouchelin in the People's response, but I'm reading from the full case. And in that case, the court mentioned United States versus Mexner, and I can give the citations if the court would like for that case. I have 2000 WL 1597736, Eastern District, Michigan, 2000. And in that case, Judge, there was similar facts to People versus Bouchelin. However, there is a contrast. So in United States versus Mexner, there was a 911 call placed. However, the caller hung up. There wasn't any information given to the 911 dispatch about any emergency, and the police were then dispatched to the home in that case. When the police got there, they knocked on the door. They didn't receive a response. At first, they didn't hear any sounds or any struggles or anything that would give rise to an emergency situation going on inside that home. Once they did get there, they came into contact with the defendant, who refused the officers to come into the home. And at that point, they detained the defendant and went into the home. So in that case, Judge, the people found that there actually was not an emergency circumstance that arose for the police to go into the home without a warrant. So using that case, Judge, like I said, comparing it to the instant case, in this case, there was actually an emergency due to the 911 call they received, and due to the safety of the public and the safety of the officers. The court, or the court in People versus Bouchelin, found that there was reasonableness and the probable cause to search that home and found whatever evidence they found in plain view. Now I'm asking the court to take into consideration People versus Bouchelin again, because I've noticed that defense counsel had that U.S. Supreme Court case cited where they said unless there was an exigent circumstance, which in this case there is. So again, Judge, the people are asking the court to deny defense counsel's motion to suppress the evidence. And if the court is not inclined to do so, after hearing the people's argument, the people are asking the court to set the evidentiary hearing for further consideration on the motion.
Well, I want to ask you, so the case that you just cited, and then at the sort of towards the end of your argument, you said that the court allowed the evidence that was found in plain sight. Let's talk about the plain sight. Mr. Clark in his argument says that if the court were to view the body cam, what I'm going to find is that the gun was not in plain sight, that it was underneath some stuff, and they had to move stuff to get to this BB gun. So if it's not in plain sight, then how do they get it without a warrant?
Well, that goes to the people's argument for the emergency circumstance to search the area where the gun would be. So no, the gun was not in plain sight, Judge, but in that case, that's given an example of the officers going into the home to even start the search warrant. and finding what they found in the home. So it's not in plain sight, but it does give the rise for the emergency circumstances for the officers to enter that area of the porch and find the gun.
Final thing before I allow Mr. Clark to have any rebuttal. So it would be the people's position that at the point that Mr. Pacheco is taken into custody, placed in the police car, that there still would exist an emergent circumstance?
Based on the 911 call that there was a weapon, Judge, and the officer did not find a weapon on Mr. Pacheco, yes, because at this point it's still a safety for the public and a safety for the officers to find the gun that was reported in the 911 call.
But couldn't they just have put Mr. Pacheco in the car and then come to the magistrate to get a warrant to search the porch while he's still in custody and while they still have eyes on the porch?
But that's not the people's position, Judge. In this instant case, like I said, there was a call from the complaining witness that there was a weapon on the scene. So at that point, when they didn't find the weapon on Mr. Pacheco, the police continued to search for the weapon to secure it and secure the safety again of the officers and the public at that instant time, Judge. So that's where the I guess the level of the exigent circumstances arise, because there were reports of a weapon.
Ms. Clark.
First of all, let me correct a factual point you made. The porches on these units are independent of each other. There are no common porch. This porch belonged to my client, period, his apartment. So there is no commonality between the porches at all.
So it's your position that Mr. Pacheco's neighbor
Has no access to this porch.
and I'm talking about, when I say neighbor, so it's the fourth, like fourplex, and then, so there will be two on the bottom, two units on the bottom and two on the top.
Yes.
And each unit has their own porch. Now, as far as exigent circumstances, there is no emergency here. Once my client is immediately placed under arrest, handcuffed and placed in a car 100 yards away from the porch, he's no threat to anybody, public or the police. The fact that there was a 911 call in and of itself doesn't create an emergency. In fact, if you look at the video, the incident took place over a half-hour period between the time they roll up, arrest my client, search the truck, search the front lawn area, and then finally search the porch. This takes time. There's nothing happening at all. The alleged victim is protected. The police are protected because my client's in the back of a car. There is no emergency. There is no extended circumstances. The Jardius versus the Florida State versus Jardius prevails on the issue that you need a search warrant to search someone's house.
Okay. All right, so here's one. I'm going to read Jarvis in its entirety. I did not. Because two, even the other case, Ms. Ritter, that you cited, that seems like it's a 2000 case. The site that you gave is a Westlaw site. So there should be actually a permanent site. The 2000 WL 1597736 Eastern District 2000, that's a Westlaw site. By now, that should have a different site. That shouldn't be still citing from Westlaw. And then notwithstanding, that is still a 2000 case where the Jardius case is 2013, which would appear to be still the prevailing law. The second thing is, it does matter. So let me say this, it does matter whether the porch is independent. It does matter with court decision, whether the porches are independent porches or if the neighbor has access. Because if the neighbor has access, then he doesn't have an expectation of privacy there. So the court is going to set the evidentiary hearing. I thought I wasn't going to have to, but I am going to set it because I would need to see evidence of the porch to even determine if Mr. Pacheco, how do you pronounce his last name?
Pacheco.
Pacheco, now I'll keep wanting to put another E in there. If Mr. Pacheco has a right to privacy, if he does have a right to privacy based upon the way the porches are made, or I shouldn't say a right to privacy, but an expectation of a higher expectation of privacy, because I can still look on a person's porch and see whatever I want to see. And there is nothing illegal about that. But then if the officers did in fact have to move things around, then that requires the court to find that the exigent circumstance existed at the time that they were moving these things around. Otherwise, it's an illegal search of all that. I agree with the defense that a 911 call in and of itself does not create an exigent circumstance. But I want to now compare the cases, the two Supreme Court cases, but it sounds like Darius is the one. Let's set up evidentiary hearing because I need to see the portraits. It seems like it's only necessary for one witness unless you all think differently. Whatever officer had that body cam and did the search, are they the same officers?
I don't think so, because
okay.
the body cam lady was female and there was a male who searched.
Well, they might be.
However, I would stipulate to the court, just viewing the one body cam, because it shows everything, even without the presence of a police officer, but.
Oh, okay, well, no, Ms. Ritter, you shake your
I
hand.
want my officers there to testify as to what happened when they arrived, so I'm not stipulating that.
All right, so let's set it from here. Let's put it on an afternoon. And let's do, are these, well, it's body cams, so it's Detroit police?
Yes.
Yeah, okay. Are you available March 19th, council, in the afternoon?
19th?
Yes. No, I didn't mean it. I didn't mean it. I was looking dead at the date and saying a different date.
Okay.
Are you available March 13th
Yes.
at 1:30?
Yes.
All right. So this is what I need you to do, Ms. Ritter. I'm gonna tentatively set the evidentiary hearing for March 13th at 1:30. But I need the people to make sure the officers are not on furlough. I don't want to get here that day and then we say the officers are on furlough. So today is the 15th. Can the people confirm by next Tuesday, the 20th, whether those officers are available for that hearing?
I can have that confirmed by tomorrow.
You always have to go over and above and beyond. Okay, well, let us know tomorrow if the officer, look, I'm trying to give her extra time. She wanted to.
No problem.
All right.
Judge, is there any special notice or something for the court to play a body cam video?
No, what you mean? What do you mean?
Well, I want the court to view the video.
Oh, absolutely. That's the whole purpose of the hearing.
Okay.
So the people will present the body cam video and then we'll view it. How long is it? Is it long?
No.
Okay. All right, but she's gonna let us know tomorrow if they are available that day. If not, my clerk is gonna call you for a different day.
Very
Okay, all right, anything further?
Yes, my client asked me if the court would consider removing his tether.
Yes,
He's had the tether on for 7 months.
yes,
9 months.
yes, it's removed, I'll remove it.
Thank you.
Judge, can we make sure there's a no contact order still with the complainant witness and the
I
defendant?
have a problem with that. He's moved and has no contact.
Oh,
I
okay,
still want that right now, my stepmom.
Okay, well, yes, I'm gonna remove it. That's enough time to be on the.
Thank you.
Appreciate it. Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. He's going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm